A district court judge ruled on Wednesday that a portion of Amendment 71, which was passed in 2016, is unconstitutional. Judge William J. Martinez said that because there is a substantial difference in the registered voter population between Senate districts, Amendment 71 could violate the 14th Amendment's Equal Protection Clause. Colorado Secretary of State Wayne Williams strongly responded to the decision, saying that he supports Colorado voters who decisively passed this law. Patty, were you surprised to see the reaction from Secretary of State Williams and how he couched the decision?
Not really, because elected officials, they will argue for their position. And in this case, Colorado voters did pass Raise the Bar, which really should have been called Raise the Bucks. And this 71 had two parts, and it's really important to notice that William Martinez has questions, and they have until March 9th to respond, but he has questions about one part. The first part was that you had to have more people vote. It should be harder to change the Constitution of Colorado. No one can really argue against that, because if you look at the Colorado Constitution, there's a lot of strange stuff that has been voted in. So Raise the Bucks raised the number of people who had to vote in an election to change things constitutionally to 55%. I think that's fine. The judge thought that was fine. We could have gone higher, make it harder for all the voters. But the other part of 71 that was problematic is it changed it so rather than a regular petition process, you had to get 2% of you had to be in all 35 counties getting the ballot.
Senate districts.
The Senate districts to be able to get on the ballot. And that's where the bucks come in, because it is very, very hard to go out. You've got to pay people or have a really grassroots cause to go out and get that many signatures in that many counties. And that's where the judge has problems, because it's supposed to be a one person, one vote system here in Colorado. And as we know from the redistricting fight that's going to come up right now, those 35 Senate districts are not equal. So we'll find out March 9th if the judge is going to put the whole thing on hold because of that.
David, you're our esteemed lawyer at the table today. We have the 14th Amendment. We have a split decision between one half the amendment, one half the other. Equal Protection Clause. Tell us what we need to know about what we've heard so far.
Well, Patty was exactly right. And of course, the purpose of Raise the Bucks, which was ultimately the money comes from oil and gas, who didn't want more anti-fracking initiatives, at least in a constitutional sense, on the ballot. And even the proponents of this, who were well-financed, good organization, ran a solid campaign, they couldn't even meet their own threshold. They couldn't get 2% of registered voters from every single one of the 35 state Senate districts. And if they can't, with the oil and gas lobby behind them, I can guarantee you that there is no possibility that any citizens group or anything funded at less than the billionaire level would be able to comply administratively. The judge's ruling comes out of a line of Supreme Court cases starting in the 1960s, as Patty said, based on the one man, one vote principle, which they said is part of the Equal Protection Clause in the 14th Amendment. Here, the biggest disparity is at the one Senate. The Senate districts are equal in terms of total population, but somewhat different in terms of registered voters. So that means that the disparity at one end, in one district, you could satisfy the 2% threshold with about 1,600 signatures, but in the furthest district at the other extreme, you would need 2,600. And the judge said that 60% variance violates one man, one vote. It's vote dilution that people are victimized by. The state pointed out there's 9 other states that have something like this, with some kind of geographical thing on putting things on the ballot, and the judge said, yeah, that could be a problem for those other states too, but I reject the state's argument that the right of initiative is less important than the right to vote for candidates.
Eric, Dan Haley, a friend of this table, back when he worked for the Denver Post. Now he runs COGA, the Oil and Gas Association. If you're him, are you worried that a major amendment that the whole lobby spent a lot of money to pass is possibly going to get gutted?
Sure, I'm worried. And Dan was doing a very effective job of leading the effort for the group he now represents, which is Colorado's oil and gas industry. I was opposed to this at the time. A lot of my friends and political and social circle felt otherwise, but I thought, to Patty's point about Raise the Bucks, my phrase was different. It wasn't just raise the bar. I don't think there was any argument about raising the bar, as Patty pointed out, to put something in the state constitution. But this didn't just raise the bar, it put it on stilts. I called it putting the bar on stilts. And as David commented, it makes it, if not impossible, virtually impossible to go that route. I'm neither an attorney nor esteemed, so I don't want to really terribly much comment on the legal side of it, and I guess it comes down to the distinction between districts are drawn to represent population, but Amendment 71 requires distribution of voters, etc. I think this is a setback for those who put it on the ballot. I think not only did they spend a lot of money in the process, but they spent a lot of political capital in the process. And I think the biggest question in my mind, short term, they're long-term questions, and if this piece of it was overturned long-term, I would not lose any sleep. Short-term, what does it mean for the whole 2018 initiative process and a whole bunch of stuff that's being circulated out there? And if you're one of those circulators or you're one of those proponents, what set of rules are you playing under? And I think that needs to get clarified very quickly.
Justine, do you think, I mean, we've been talking about the oil and gas people being disappointed because this was essentially the law they helped pass. Let's talk about the activists that are behind some ideas right now that might be buoyed by this decision, saying, hey, I've got a shot. Maybe it's a short window, but I've got a shot to maybe amend the Constitution. The 55% voting threshold doesn't go away, and that's still significant. But not having to get 2% registered voters in the Senate district that represents La Junta is just that I think would make it easier. Do you think activists this year are hopeful from this decision?
I think so. Well, I agree with everybody's analysis of this situation. As a grassroots organizer, we're preparing to adapt to this, but definitely I think it does make it, it'll be interesting to see how this plays out and how organizers will have to adapt, because it is difficult collecting those signatures in each district, and especially when, it's a disproportionate amount of number that you have to get in one district versus another. It's difficult. It costs a lot of money, and the ground game's hard. You bring in a lot of signatures, they get thrown out constantly. So I think that this will just be very, very interested. I'm very interested to see how this plays out as an organizer and to see how we have to adapt in the next year coming up.